The next case is Ammons versus Wilson and Company, and it asks the question, when can silence constitute acceptance of an offer? R.L. Ammons was a wholesale grocer in Ballula, Mississippi. Over the course of 6 to 8 months leading up to the events in this case, he had placed a number of orders with Tweedy, the agent of Wilson and Company, a meatpacking business located near my hometown of Kansas City, Kansas. On each occasion, he filled out an order provided by Tweedy, who sent the order on to his bosses in Kansas City, who then shipped the requested good to Ammons within a week. With the order that forms the basis of this case, this sequence of events did not take place as planned. Tweedy told Ammons that Wilson was offering shortening at 7.5 cents per pound, and Tweedy booked Ammons for 60,000 pounds of shortening. This was a booking and is really a way to say that for Tweedy to solicit offers rather than to make or receive an offer itself. About 2 weeks later, Ammons submitted an order for 942 cases of shortening. That is about 43,916 pounds of that stuff. His order was an offer to purchase shortening in the given amount at the given price. Ammons did not hear back from Wilson for 12 days, at which point they told him that they would not fill his order as the price of shortening had increased to 9 cents per pound. Ammons then sued Wilson and Company for breach of contract, alleging damages from the company's failure to ship the requested shortening. The trial court directed a verdict against Ammons, concluding there was no contract and so he was not entitled to damages. We're looking at the decision from the Mississippi Supreme Court, which looked at the question of whether it was possible for Wilson's 12-day silence to constitute acceptance of Ammons' offer. Note that even though they ruled for Ammons, the case was remanded so that a jury could decide whether Ammons' allegations of fact were in fact true. Justice Anderson turns to what is now Section 69 of the Restatement Second of Contracts to determine when, under what conditions, silence can constitute acceptance of an offer. The section is quite restrictive because we generally do not want people to have to speak in order to avoid being bound by contract. Contracts are meant to reflect the conscious will of the parties involved, not the accidental use of a default option. Taking on an obligation should normally require conscious assent from each party. Even though an offeror is master of her offer and normally can add conditions as to how the offer can be accepted, remember an offeror might say, and as an example, remember an offeror might say that an offer can only be accepted by skywriting, "I accept." But an offeror is not empowered to say you accept an offer unless you deviate from your life path. If you go to work today, I will have deemed you to have accepted my offer to sell your house for $1. Or unless you say, I love Kansas City, you will be deemed to accept my offer to buy your car for $50. Offers shouldn't have a right to make you speak in order to avoid contracting. Section 69's first exception to this idea that silence is rejection is when the offeree takes what the offerer has offered, knowing that the offerer expects payment for it. Even though the offeree is not required to speak, her taking what was offered is a conscious action and has similar social meaning. It creates an implied in fact or implied in conduct contract. Section 69's second exception is for situations where the offeror has made it clear that he will interpret the offeree's silence or inaction as acceptance. The subsection makes it seem like the offerer could say something like, if you don't say anything, you've agreed to pay me $1,000 in exchange for this book. And then the offeree would be bound to pay $1,000 unless she said something. But note the caveat. The offeree must intend for her silence or inaction to constitute acceptance, for this exception to hold. It's on the third exception that Justice Anderson's opinion relies. If the two parties have a practice of behaving as if silence means acceptance, then it may be reasonable to require the offeree to explicitly reject an offer. The justice found that a jury, based on Ammons' evidence, could reasonably conclude that Ammons and Wilson had established a pattern where silence from Wilson and Company meant acceptance of Ammons' offer, and that acceptance that was taking on a promise to ship the requested items within the week. When Ammons did not hear from the seller for 12 days, he could reasonably conclude that they had accepted his offer by silence and that they had a valid contract. Let's take a look at a couple sections of the UCC that bear on this case. Section 1-201B3 of the UCC defines agreement as a bargain of the parties in fact as found in the language or implication from other circumstances, including course of dealing or usage of trade or course of performance. This is a bit broader than the rule we saw in Section 69 of the Restatement. Subsection 1C of the Restatement only explicitly discussed the prior course of dealings between the two parties involved in the contracted issue. The UCC expands this to cover usage of trade, that is, the general pattern of behavior in the industry at issue in the case. If the parties know that silence is viewed as acceptance in their industry's trade usage, then they may be bound by silence as acceptance. UCC Section 2-206 goes into more detail about non-verbal ways to accept an offer to buy. Subsection 1B says that prompt promise to ship or prompt or current shipment of the conforming goods constitutes acceptance. Subsection 2 says that sometimes the beginning of requested performance constitutes acceptance. While none of these options is an explicit verbal acceptance of the offer, they are all clear indications that are akin to implied in fact acceptances, that the offeree has understood the offer and intends to go along with it, to accept it. In this case of Ammons versus Wilson and Company, Wilson's general practice of simply shipping the goods in response to an order looks very much like subsection 1B's prompt or current shipment of conforming goods. So here's a quiz. Gloria sends an order for 100 widgets to Wilson's Widget Incorporated. WWI mails her back a box of 100 widgets of the type she ordered, but they're defective. Can Gloria sue WWI for breach of contract? Well, the answer is yes. Gloria can sue for breach of contract. Her order was an offer to buy widgets at the listed price, and WI's prompt shipment indicated its acceptance of her offer. The parties therefore have a binding contract, and so Gloria can get whatever damages would ordinarily be available for receiving the defective products. In our discussion of Ammons, we've seen that the general rule is that parties must explicitly indicate their acceptance of an offer in order for a valid contract to arise. However, there are exceptions in situations where actions indicate acceptance, as when they ship goods in response to an order, or when the parties have established a pattern where silence indicates acceptance.